Good afternoon, everyone. My name is Philip Rees from ByteCubed. Thank you for taking the time to participate in today's workshop. This is the fourth in a series of workshops delivered in this webinar format. The first three workshops were designed to assist you with both your understanding and preparation of key elements of your 18.2 and 18.B SBIR STTR BAA submissions. Today's workshop focuses on intellectual property as it relates to the SBIR STTR program. Please limit today's questions to the scope of this workshop topic. Information contained in this webinar and accompanying materials is for educational and informational purposes only. Nothing in the webinar or accompanying materials should be construed as legal advice or as an offer to perform legal services on any subject matter. Today, we are going to discuss several areas of intellectual property and focus specifically on the SBIR STTR data rights and how companies can better manage their IP. That said, the objective of today's workshop is to provide you with a basic understanding of patents, trademarks, copyrights, trade secrets, and SBIR STTR data rights. All participant microphones are muted for the duration of the webinar. Today's workshop is structured as follows: presentation, Q&A, summary, and post-workshop survey. At the end of this webinar, you will be automatically redirected to a page where you will be asked to provide feedback regarding today's workshop. It should take you less than 5 minutes to complete the survey. We will also send the survey to you via email. Within 30 days following this workshop, we will send participants the transcript of the workshop as well as frequently asked IP-specific questions via email. Due to the nature of this workshop, we will not be answering company-specific questions. Additionally, all responses are for informational and educational purposes only and should not be interpreted as legal advice of any kind. Today, we are joined by George Wang from Manava & Kang. George has over 17 years of experience in intellectual property law. George is a registered patent attorney with diverse legal experience in litigation, prosecution, counseling, licensing, commercial and government contracts, and compliance, all of which were refined from many years of in-house corporate, private, and government practice. Prior to Manava & Kang, George worked with us at ByteCubed as our chief IP counsel and also as senior IP counsel at General Electric. Prior to that, George worked at 2 internationally renowned law firms, and he was also a patent examiner at the USPTO. George has specific experience related to IP and contracts within the SBIR STTR program, and has advised hundreds of SBIR firms on IP and overall legal strategy. With that introduction, I'd like to turn the presentation over to George Wang. George, please take it away.
Great, thank you, Phil. So today's topic is on intellectual property, and we'll be talking about the different types of intellectual property, how that affects your business, and other things that may be important, such as data rights, licensing, litigation, enforcement. Hopefully, it's a lot of material to go through, but I'll do my best to give a general overview, and like Phil mentioned, at the end, I'll have some time for some Q&A to answer slightly more directed questions. Now, let's go to the first slide, which says, what is intellectual property? For most of these presentations, I will not read the slides. I believe you'll have them, so you'll be able to refer back. But I did want to read this one particular slide to sort of set the foundation so that we all are on the same page as to what intellectual property really is. And this definition is taken from WIPO, which stands for World Intellectual Property Organization. It's sort of a governing body for IP jurisdictions all over the world. And their definition of IP refers to creations of the mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. IP is protected in law and enables people to earn recognition or financial benefit from what they invent or create. Now, by striking the right balance between interests of innovators and the wider public interest, the IP system aims to foster an environment in which creativity and innovation can flourish. And like I said, I'm not going to read many more slides throughout this presentation, but this is an important definition for us to have in mind especially as we cover the different types of IP, especially as they pertain to SBIR, STTR awardees, and how they interact with your particular business. Next slide, please. Now, IP can help your business in dramatic ways. Now, startups, small companies, big companies, they're the engine that drives innovation in the United States. Now, small and large businesses alike, they generate new ideas at every turn. Now, from inventions that power our portable devices to the brand names and logos that are attached to those products, with the right knowledge, your company can convert these wonderful next-generation ideas into valuable intellectual property assets. Now, most entrepreneurs like yourselves don't spend too much time focusing on your company's IP. You probably spend a lot of your working day creating and perfecting your product, executing your business and marketing plans, and rightly so. But IP cannot be an afterthought. In most cases, actually, entrepreneurs have the sense that their business has intangible assets in the form of IP, and that those assets do have some value, but tend to think of IP or intellectual property as a legal issue that maybe can be dealt with by the lawyers, or maybe something that you can push off until your company actually begins to succeed financially. Now, this common approach is a mistake, and it only adds to the many challenges on the difficult path to business success. If you understand the value that IP can bring to your company, you have a good chance of defying the odds and excelling where many other companies have failed. And now, at the intersection of technology, business, and law is intellectual property. Therefore, it's critical to any company, especially a budding company like yours, to really understand what IP is and how to use it for your business goals. Now, IP can be used in a variety of ways to bring value, and as you see on this slide, you can use it to protect core products and services. You can use it to expand your market share. You can use it to discourage people who want to copy it, infringers, and to be litigation ready in case someone tries to sue you. You have the ammunition to sue them back. You can use it to help acquire venture capital, get more funding. People like to see that you're innovative, you're patenting your ideas. Demonstrates technology leadership if you have a nice portfolio of patents and other IP. It helps create valuable assets, and ultimately, at the end, it can be used to generate revenue. Now, to use a football analogy, and I know Phil likes this, IP can be used for offense, defense, and special teams. And when you execute on all facets of the game, especially if you guys are football fans, you guys will know you'll win games. And IP can do that for you. And when you win many games for a long period of time, you win Super Bowls and you build a dynasty. Next slide. Now, it's important for me to point out that the most successful businesses in our country and around the world build their businesses around IP. And IP is an important business tool that they implement very successfully. Now, valuation experts estimate that IP represents the largest asset class held by American companies and representing about 40% of the value of all of their assets. Now, IP represents significantly larger percentage for even the most successful companies, especially those in the S&P 500. And by some estimates, IP represents up to 90% of the value of these companies. Okay, so think about it. Google, a company that we all know, they're worth about $400 billion. Now, how much of that do you actually think goes into servers, equipment, land, building, office furniture? No, the majority of the value of Google is held in their IP assets. And so when you think about that, considering how much IP represents to their value, it's important for us and for you to understand how to create value in your business, especially understanding how IP can fit as part of your business plan. Next slide. Now, there are four main types of intellectual property. There's patents, there's copyrights, there's trademarks, and there's trade secrets. We'll also talk about data. Even though technically data is not IP, data is just data. It's pieces of information. But data belongs in this IP discussion since data can also be owned, it can also be licensed, and it also has significant value at times. And we'll cover each of these in detail as we go along. Next slide. So patents. This is probably the most important and most valuable piece of IP that you'll interact with or be in possession of. Now, patents is an exclusive grant by the government to make, use, or sell a particular innovation. And there's several types. There's provisional, there's non-provisional, there's utility, there's design, and there's plant patents. We're not going to spend the majority of our time today talking about most of these, especially plant patents, not too much on design, and not too much on provisionals. The ones I want to focus on are more towards the non-provisional utility patents. These are the most valuable. Now, the whole idea of a patent is predicated on this idea that innovation spurs innovation, right? So rather than keep your invention a secret and limit innovation, the government wants you to disclose your invention, for example, in a patent, which eventually becomes a public document for everyone to see. Now, the idea behind the patent system is that if you tell the world the problem that you're trying to solve, how it works, all its variations, and why you think your invention is so great, this spurs other inventors to innovate as well. And all this creates a culture of innovation that fuels our country's economic success. Now, the flip side of this is that disclosing your invention to the public is a scary proposition. So the patent system here and internationally has been devised to protect you when you share this information with others. So in exchange for your disclosure, the government wants to give you exclusive protection, specifically the right to exclude others from making, using, or selling for a particular period of time. This comes in the form of a patent. The patent document itself then really becomes a contract between you and the government. You agree to share your information to the public, and the government agrees to protect you from theft, counterfeiting, or other forms of infringement. Again, this is based on the theory that innovation spurs innovation, and patents are predicated on this particular public interest. Now, the term of a patent is 20 years from the time of filing. Patent coverage is national in scope, so if you want to get protection in different countries, you have to file a patent in all those different countries. Now, there's an international patent consortium. We're not going to talk about that in depth today, where you can actually file patents in a group of countries all at once. But again, that's too advanced for this purpose, but just know that that's part of the arsenal that you have. There are different varieties, like we mentioned, utility, design, plant patents. Utility is going to be the most important for you. Special note on provisional patents, they actually don't convey any legal right until they're actually converted to a non-provisional patent. They're simply placeholders for the purposes of time, okay? Utility, non-provisionals are the most valuable, but at the same time, they are the most expensive to acquire. Next slide. Now, because many of you are government contractors or SBIR, STTR awardee or participants, you will have received funding from the government. Now, government funding affects the typical process on how you would get a patent and how the particular rights are apportioned. Now, for all SBIR and STTR participants, if an invention was originally conceived or actually reduced to practice in connection with government grant or funding, there are 3 steps that you must take in order to secure patent ownership rights. Now, if you have IP, that was generated before you receive funding or outside of the funding, this does not apply. You can just go straight and apply for a patent, for example. But if you receive funding in connection with a government grant, there are 3 steps you have to follow in order to make sure that you have some sort of right to that particular IP. And the 3 steps are disclosure in writing, election to retain title, and 3, to actually apply for the patent application itself. Now, failure to do any of these steps can actually jeopardize your rights to ownership and give it straight to the government because they're paying for it. And if you're actually filing something and you don't go through these steps, there is a chance that they might own the technology that you're generating for them at the end, and you might have to pay them royalties for something that you brought to the table. So these 3 steps are actually very, very important. Now, if you meet these 3 steps, the government will have licensee rights, but you will have ownership rights, and you'll be able to do with these particular patent rights as you see fit as the owner. We'll talk about this a little bit more when we talk a little bit about licensing later on. Now, some of you might ask, well, which out of these three are the most important? If you ask me, I would say the first one is the most important. Disclosure to the government in writing. Now, there's a system called iEdison. You can look this up. A lot of the government contractors use this. You could just put up digitally put up type in, in a paragraph or a couple sentences that you have a particular invention. Now, again, this is only in connection with government funding if this idea was reduced to practice or is conceived from funding from the government. Once you do this, at a minimum, you will have non-exclusive worldwide licensee rights for this technology. So you'll be protected somewhat. But I do recommend going through all these three steps to make sure that you secure your IP, especially patent rights, as it pertains to government funding. Okay, we'll move on. Next slide. Trademarks. We won't spend too much time on this. We missed a trademark slide. All right, trademarks. Branding is especially important for companies. Trademarks helps with that a lot. These are generally words, phrases, or symbols. There's nothing in the FAR or DFARs where the government wants any type of, rights to your trademarks. I do suspect that down the road this might happen, but at this time, it's good to think about your branding of your company and to think of ways that you can continue to protect that, especially while the government doesn't really have an interest in this. Now, federal registration for trademarks is not required, but recommended if you want broader protection. And the term of a trademark is forever, as long as its use continues. Okay? We'll move on to copyrights. Copyrights is also another way to protect your intellectual property, and a good way to think about this is, think of like the artistic works, think about music, think about books. Those are generally protected by copyrights. These are usually for literary works, musical works, dramatic works, choreographic, pictorial, graphic, sculptural works, sound recordings, architectural works. The reason that this is important maybe for some of the companies is software can also be protected by copyright as well for the specific code that you use to generate that. We'll talk about that in a little bit. Registration, like trademarks, is not required, but recommended, especially for recovery of damages. Scope of a copyright is worldwide, generally, and the term of a copyright is the life of the author plus 50 years. Now we'll look at trade secrets. Next slide, please. Now, there's a general misconception about trade secrets. It's that if you don't patent something, that it automatically becomes a trade secret, and this is completely 100% untrue, okay? In order for something to be a secret, in this definition, you must document what that something or what that secret is. If it's a formula, if it's a set of ingredients, if it's the actual steps of a secret process, it has to be documented and even time-stamped somewhere, okay? Second, you must use reasonable efforts to maintain its secrecy, right? A single vault, a double vault, retina scan, whatever sort of security measures you can think of. The more valuable your secret is, the more effort you are actually expected to put into keeping it from leaking out. For a patent, like we discussed, you're relying on the government to protect you in exchange for your disclosure of the invention to the public. For a trade secret, you're saying, nah, I don't trust the government. I'm going to choose to rely on me. And if there's a breach, for example, a disgruntled employee who knows of this secret or an accidental public release, the amount of reasonable effort that you put into keeping this a secret will come to the forefront when you're trying to seek damages on your losses. So please know that a trade secret doesn't automatically happen. It has to be documented. It has to be it has to be time-stamped. That way you can go back and say, no, we did keep it a secret. It wasn't just laying on my desk for everyone to see. Instead, we put it somewhere, and if someone can show that it was stolen or taken away, then you have proof to say that you tried to keep it a secret, and you can still recoup some damages at that point. I have a chart, next slide. I have a chart here for patenting versus trade secrets. I know that this is a big question that some folks have. Yeah, the title for this is incorrect. It should be patenting versus trade secrets. But I'm not going to go through this in detail. If you have questions about, which one should I go for, you can look at this chart and see the pros and cons. Now, go back to the other slide that talked about protecting software. Software is a unique animal. When the patent laws and IP laws were developed, they were not thinking about software. And so, for software, you can use patents, trade secrets, and copyrights to protect almost any number of IP to protect software. That could be very challenging, but it could also be very profitable in the sense that you have a lot of different options to choose from. And so, selecting which form of IP to protect your software is going to be based on your strategic business structure for that particular software. But it should include a mix of patents, trade secrets, copyrights, maybe design patents. However you devise will be strategically important for your business. Now, in the next slide, I have a comparison of software business models. I'm not going to take the time to go through this in detail. For those of you that are in the software business or have innovation that is software-based, you probably have thought about these particular models and how to build a business around software. There's a traditional model all the way through to the internet model, or even a software as a service platform model, where you're making money on the software in a different way. I won't, again, like I mentioned, I won't take the time to go through this. You can go through this on your own. But the IP that you select to protect your business will depend on which software business model you actually wind up going with, right? For example, if you go with the traditional model where you're actually delivering software to your customer, you probably want to get some sort of patent or copyright protection because the code or the software will be available and the customer will be able to touch it, see it, tweak it, and steal it, okay? So you want to probably have something, a form of IP where you can kind of protect that a little bit better. If it's more of a SaaS model, hosted on the cloud, for example, you probably want to, you probably don't need to rely so much on patents, but you can rely on trade secrets and some form of data protection. And so depending on how your business is structured around software, that's probably how you're going to think about your IP strategy. Okay? Next slide. So we're going to talk about data and rights to data. Now, before we talk about the rights to data, it's important just to be on the same page about what data actually is. Now, data itself is not very meaningful, and it's generally not considered IP, but we lump it into discussion because large amounts of data, especially, may have significant value. And this slide illustrates basically two ways that you can have rights to data. And one is ownership rights, and the other one is a licensee rights. And in this case, by default, the contractor will retain ownership, and the government will generally receive a license use right. Okay, so any data that's generated as part of your SBIR award or STTR award, you will have the contractor will retain ownership, and the government will have license use rights. Okay, now FAR and DFAR rules, allow the contractor to do this, maintain ownership of technical data, computer software. The government likes to be able to have these licensee rights, and they usually, fall into three categories: unlimited rights, limited or restricted rights, and government purpose rights. Now, again, data rights within the government contract context is very complicated. FAR and DFAR rules specifically define what technical data is and what software is and what the various rights are associated with it. What we're talking about today is just going to be a general topical survey. So if you have specific questions or need to know certain things about your business, you'd have to look more closely at the specific FAR and DFAR provisions that govern your awards. Next slide, I have a chart that kind of talks about these various rights. You can always refer back to this. I believe this presentation will be available to you, so you can use this as a resource afterwards. Next slide. Now, within the SBIR and STTR context, there's actually a level of data rights that goes beyond just the normal FAR and DFAR rules, that's actually governed by the SBIR directive. And so if you're a SBI or STTR firm, you're going to have SBI or STTR data. And in order to have SBI or STTR data, which there are specific benefits of having that data because it's sort of the extra protection that the government gives small companies and small businesses, there's three basic attributes of this data in order to be afforded that protection. Right? It needs to be recorded information, and this can include source code, sketches, drawings, formulas, equations, reports, SBIR final reports. It needs to be of a technical nature. Company background, cost and pricing is not technical, so that won't be covered as SBIR data. And it has to be generated under a SBIR or STTR funding agreement. Now, SBIR funding may include grants, contracts, co-op agreements, and other types of funding, whatever the government chooses to make for your specific award. Okay. Now, these two things that need to be stressed as part of technical data includes marking requirements and maintenance of records. We'll come back to this in a little bit later, but we'll talk about each of these a little bit more specifically. So in order for something to be recorded data, next slide, it needs to be reduced in writing and contained in a written document. Now, SBIR data can be source code, sketches, like I mentioned. SBIR protections do not apply to ideas or concepts unless they are actually reduced into writing. Okay, SBIR data protections protect ideas contained in a written document, but not the idea itself without the writing. And so it's important to be able to have that reduced to writing. And so basically the SBIR framework, the SBIR regime, is that the government obliges itself to not disclose your innovation, your data, per se, to other vendors to shop it around. And that's a good thing for SBIR participants. And so we'll talk a little bit more about this, maybe with regards to NDAs and such. But it's important for each of the companies here to understand that this SBIR data protection is actually good data protection for you guys, and it's good, and it lasts for a good amount of time for you. And the government promises to do that so that you'll be open and share this with them, and they just want to get first dibs out of it. But it is important to know what is covered and what's not covered for your benefit. Next slide. Again, this must be technical data. Non-technical data such as cost and pricing doesn't fall under this. That would be protected under something else, such as the Freedom of Information Act, otherwise known as FOIA, or protected under some other privacy act. But for SBIR non-disclosure obligation, the government does not extend to such information. So proprietary data is protected by these other means. Now, non-technical information such as background data in the company is not protected. It should be disclosed carefully and with that knowledge in mind. So the technical requirement is that it must relate somehow to the SBIR technology being developed in phases 1, 2, or 3. Okay? And this particular SBIR data will be something that a SBIR firm will seek to protect. Information or data that the SBIR firm advertises on its website is not something that it feels it must protect. You have to kind of basically genericize this. If you kind of share your SBIR data to the public or unleash it on the web, the government's going to say, well, this is not something that could forfeit your SBIR data rights. So that's something you want to think about, especially as you're sharing or marketing some of your technical data. Lastly, I won't go into much more detail. In order to qualify as SBIR protected data, it must be SBIR or STTR funded. So let's make sure we get to that next slide. So proprietary data developed with private funds is not SBIR data, but it might be protected in some other way, just not by the SBIR non-disclosure obligation of the government. Proposal information is not SBIR data, and then there's this description in the SBIR directive that if SBIR data is mixed so thoroughly with non-SBIR data that it cannot be separated, it is all considered SBIR data, and this may include, this is common in source code and software innovations as well. So that's something to think about. If you develop something privately and you work on something with the government, but then now it's so entwined, on the one hand, it could be good for you because now it's protected under SBIR, but if you had some sort of other IP around that beforehand, now that could also be bad because it might eliminate those IP protections because it's so intricately entwined, it becomes SBIR data, okay? Ooh, if anyone has questions, we could probably address that a little bit later. Next slide, I have a chart here that kind of outlines, which one you should choose, why patenting might be better in some situations, why using and relying on the SBIR STTR data protection will be beneficial in others. Basically, the difference is between patenting and data protection, or SBIR data protection, is the level of disclosure, right? To patent, you need to share your invention in a patent application. To get SBIR data protection, you just need to mark that data, and that data needs to be recorded, technical, and funded by the government, okay? Now, for SBIR participants, there are additional nuances, which you can look at in this slide. And basically, this non-disclosure obligation of the government and the accompanying technical rights to protect SBIR firms, it attaches to technical data under the SBIR contract. So to the extent that the SBIR firm discloses one, some, or all of its technical data to the public, it loses protection rights. So you want to be careful of who you share this technical data with. If you share it outside of the government, you might be forfeiting some of these rights. So do be aware of that, okay? Move forward. Next slide. Like I mentioned, there's 2 requirements in addition to those 3, marking and maintenance of records. These are things that are stressed by the FAR and DFAR, so make sure you have some sort of system in place to mark what is actually SBIR protected data. Okay. Moving on, I'll give you an example. Patenting versus SBIR data protection in a sort of a scheme here. There's usually going to be three parties involved in any kind of business deal, especially for a SBIR firm. There's the government, there's yourself, and then there's third parties. This could be another subcontractor. This could be the big guns, big government contractors that may want to use your technology, and so there's some flexibility with that. But there's usually going to be 3 parties here, especially as you try to commercialize your technology. So now you, the SBIR firm, you might have a great idea or a great innovation. You receive a SBIR award, and you're in development and creating value. Now there's this government agency that's granting you the award, and they're obliged to protect your data, and in return they get dibs on evaluating your technology to see if they want to be a potential customer. Now there are also 1 or more third parties out there. These may be commercial companies or VCs. They may be interested in funding, buying, or using your technology. These may be the Lockheeds, the Northrops, the Boeings. Now the question that I see a lot is, what are your options and what are your specific protections that you should seek to protect your technology as you try to commercialize? Now remember, you receive SBIR funding, therefore the government obliges itself not to share your recorded technical and SBIR funded data with anyone outside of the government for a period of 5 years. But if you're going to give a presentation to a third party, and in that presentation you share the secret sauce of your technology, including SBIR data, now the government's non-disclosure obligation has now been forfeited in your detailed sharing to this third party. This means if your potential deal with the third party now breaks down, no commercial deal has been reached, the government itself, especially if it finds out that you did this, is no longer under this non-disclosure obligation and can legally and rightfully share your data with a third party for them to create that technology instead of you. Now, lucky for you, you're able to sit here and listen to all this information about SBIR data protections and patenting, etc. And so before all this happened, you knew about this and you decided to patent your innovation instead. By doing this, you no longer relied on SBIR data protections, but relied on patent protections. And so what this gives you is free range to engage with third parties as well as with the government, and they will be treated as a commercial-like entity. So if you decide to give a presentation, this presentation will not destroy your patent protections, especially if it's still pending, even if it's still pending. Now the flip side of this is that the patent costs money to prepare and to file, and it's a significant investment. It requires you to typically forfeit your SBIR data protections when you file, to the extent that it overlaps with the content in the patent. Now, because of your great IP savviness, you're knowledgeable enough to isolate the SBIR data that is core to your technology and not disclose that in the patent filing. And in your patent, you only disclose the overall system and method without including those actual SBIR data parameters, the actual core data content as well. And so in your pitch presentations, you only share what's in your patent and not what's actually part of your SBIR data. And in this scenario, you're able to share technology to the government or commercial third parties freely and still rely on your non-disclosure obligation to protect your core SBIR data. In some ways, this is the best of both worlds. And so what you can learn from this is that it's important to know what your business is built on, to know the IP and how that overlaps with your business and which ones are going to be more valuable. If you're in the software space, this gets a little tricky, but let's say if you're doing something more mechanical where things are more easily reverse engineered, you want to focus on a patenting strategy probably. If you have processes that are hard to discover, maybe a trade secret or data rights may be better suited for your business. And so depending on your business, depending on the technology, depending on your resources, that's how you're going to have to decide on what IP strategy will be best suited for you to protect yourself. Now, this is a good time to also talk about NDAs. I want to remind us that NDAs are generally helpful, but they're not ironclad. There are a few situations that I've experienced where having an NDA in place will not actually help you and actually result in forfeiture of your IP rights. Again, I share this not to scare people, but just to help you to be aware that it's not ironclad. There are holes in the whole process and practice of NDAs. I'll give you an example. If you have not patented your technology, for example, and you're pitching it to a third party, you may be asked to share sensitive information with that third party. You may feel that having an NDA in place is important to protect both sides, and most of the time it is. And most of the time it will, and it's sufficient enough. But in situations where you're sharing computer code, for example, it might not be. Because let's say you hand over the code to another party, and this handing over of the code in patent law may be considered public disclosure. And so let's say you decide not to patent your technology yet, but handing over the code is, may be construed or constitute public disclosure, or maybe even an offer for sale. This will bar subsequent patent protection. But if you patented already, not so much a big deal. Even if that code is inaccessible, disabled in some way, but the fact that you're handing it over so that someone can touch it or hold it in their possession, this might still qualify. So a lot of NDAs I see don't account for this. There are ways around this, but I just want to make sure people understood that NDAs are not ironclad. There are holes, and you want to be careful depending on your technology and what you're handing over, and then that NDAs don't always protect you as you think. All of this gets pretty tricky, but for the purposes of our discussion, we're just not going to have too much time to go in through all of this, but my goal here is to raise some flags so that as you're working on your commercialization, as you're working on deals, as you're interacting with the government and various parties, my goal is to help you to see the red flags so that you know when something might not be right and that you take action before it's too late. Now we're going to move on to some licensing and litigation concepts here. If we go to the next slide, we'll talk about portfolio development and monetization. So the way I like to look at IP is one piece of IP is good, but at the end of the day, I analogize it to be like a brick, right? Portfolio development is not just having bricks and having a pile of bricks. It's having the foresight to build a brick. Using the brick to build a brick wall, for example, so that you can protect yourself. You can build a wall that separates you or your customers or your competitors, right? Having a pile of bricks is just a pile of bricks, but portfolio development takes work, it takes time, and it takes strategy. Now, when we talk about monetization, it's not always just litigation, right? When we talk about IP, because of the world that we live in, all we hear are the Apple, Samsung litigation, IP disputes, and all of that gets sensationalized. But a lot of IP doesn't always make the courtroom, and it's not always about these legal fights. Monetization can include that, but it also includes anything that creates value, right? Licensing, opportunities, strengthening your products and services, creating new markets, deterring competition, all of this creates value for your company. And licensing commercialization is ultimately a part of your portfolio development phase. You know, licensing is not the only way to create value. You can use it for defense. When someone tries to sue you, you can enforce them against competitors if you believe they're infringing your patents. You know, I had a situation where a competitor was planning to roll out this new next generation technology that competed with my clients. But because we strategically developed a patent portfolio in that space before they did, that broadly covered our technology, but also covered their technology as well, when it got time for the competitor to launch their product, they couldn't. It was actually well-publicized product that they couldn't even market it. And they actually admitted to the press that they couldn't get around our IP. Now, to this day, I'm not sure if they were able to sell any one of their products. They might have just moved on and continued to do the research and development on their other products. But we actually ended the competition before it actually even began. And so how do you even quantify that? But that's value, to be able to shut down a competitor completely before they could even launch. And that's what the power of IP can actually do for your company. And so licensing is actually a big part of this, but I just wanted to make sure everyone understood that licensing is not the only way to get value out of your IP. Sometimes it is about creating a market. It is strengthening your services. It is establishing boundaries, creating a wall, so to speak, that your competitors are aware of where they can't encroach. All of this provides value. And having some IP, especially for younger or smaller companies, can help you secure other types of financing and funding. Okay. Now, I'm not going to go through this in detail. Next slide. There are three main types of technology licenses that I want to make sure that people are aware of. There's a pure IP license, there's a product or tech license, and then there's a standard license. You'll hear licenses referred to by these names or alternative names, but it's basically important to think about them in these three particular categories. Now, license may be for certain IP rights only. For example, a license to practice a particular identified patent or to copy or to distribute a certain work of authorship. A license may be also for all of the IP rights to any kind of particular that are necessary to produce, make, or use, market a particular product or a particular technology grouping. And then there's also a license that may be for all IP rights necessary in order to create and market a product that complies with a technical standard or specification. Okay? And those are generally how you're going to have licenses structured in one of these forms or some sort of hybrid form. Okay? Next slide. Again, there's so many nuances of licensing that we can go into, and each of them will be case specific, so I'm not going to have the time to do that. But here is a slide to just sort of help you with your licensing strategy and licensing negotiations. This is sort of a best practices. Right, every company has different technology, different leadership and strategies, various markets, competitors, customers. So it's impossible to provide, a one-size-fits-all approach for all of your companies in a short presentation like this. But these are 5 key ingredients that I think that will be important for successful licensing that can apply broadly across all companies. For example, here, ownership of IP. This is super important. You want to make sure that you own IP if you're going to license it or have at least licensing rights. That needs to be hammered out right off the bat. Second, you need to understand the various kinds of licenses, which we just talked about. Third, licensing only technology licensing in particular only occurs in the context of business relationship with other agreements. And this is important because these agreements are often interrelated, whether in one document or integrated in another bigger document. It's important to consider practically how these terms affect each other because of timing, pricing, overall value. For example, if agreeing to development of a product without deciding issues related to IP, that might be problematic. Or who will have license to manufacture. This would be covered in a manufacturing agreement. Or what price one party wants to buy. This is a sales agreement. So you can have R&D agreements, manufacturing agreements, IP license sales agreements. And it's important to kind of make sure that they're all sort of part of the same family and they don't have any contradictions with each other. Now, technology licensing involves negotiations, and like all negotiations, They have sides or parties whose interests are different. Most coincide in some ways. Everyone wants to benefit. So any type of successful licensing will generally occur when the negotiator understands thoroughly the benefits that are available to all the parties. So it's difficult to successfully negotiate a license where you wish to obtain the right to technology if you have little to offer in return. And so both sides of the negotiations will generally have some elements of value to bring to the table, either skilled employees, particular market, a particular avenue to exploit know-how, research facilities, different commitments, some form of IP pre-existing that you bring in. And so unlike sales transactions involving physical property, IP licenses generally involve more than just a simple question of how much do I pay, how much do I owe you. The goal is to find a good balance of value so that the license is a win-win for both sides. Now lastly, technology license involves reaching agreement on a complex set of terms, each of which has several possible solutions. So advanced preparation here is essential. Before negotiating, before talking to people, it's important to do your due diligence to know all the objectives of your side and all the objectives of the other side, and understand what you can live with, what you can't live with. I can't emphasize the importance of negotiation preparation, especially when it comes to licensing deals. You can't just have someone give you an offer and then you decide how you want to approach that. Part of your business strategy, part of developing IP strategy is to have all this in mind. And unfortunately, this stage is not always reached by companies, or it's not done well. Companies may apply for multiple patents and then just leave it at that. And so it's important for you to figure out, how you develop your IP, how you develop your patent portfolio, and how you want to integrate that with your licensing strategy. So these are some things you want to be able to think of off the top of your head, okay? Especially as you prepare for your IP and prepare towards negotiations with another company. Now I want to move on lastly to litigation. Next slide, you'll see a chart here that shows us the trend of litigation over the last couple decades. These are the cases that have been commenced since 1980. Some of the data hasn't been released since 2015 or 16, so it's not the most updated. But as you can see, patent litigation trend is just going up. Even with some law changes in 2012, you can see a slight dip, but that has continued to soar back up despite some of the law changes that were attempting to mitigate the rise of patent litigation. Many blame trolls, patent trolls. You might have heard of that term, but as you can see, litigation continues to go up, and the numbers are still going up. And so we, unfortunately, are living in a litigious society, and IP suits are going nowhere. So the reason I mention this is to help all the companies here just to be ready to understand the scope of how litigation impacts business. So the next slide here. Patent litigation requires a lot of skill and experience. Can we make sure we get the next slide? It's impossible to share everything here, but here are some litigation basics what you should look for in case you have some IP and you believe it's being infringed by another party, or perhaps you're on the receiving end of a cease and desist letter or a federal complaint. These are just some basic tips that I thought would be helpful. But obviously, consult a trained legal professional if you're subject of a lawsuit or thinking about suing someone. Basically here, patent infringement occurs when another party makes, uses, or sells a patented item without permission of the patent holder. Now, the patent holder may choose to sue the infringing party, to stop his or her activities, as well as to receive compensation for the unauthorized use. And since IP is governed by federal law, the patent holder must sue the unauthorized party in federal district court and in government contract situations that might be in the court of federal claims. Now, patent holders must bring infringement actions within 6 years of the date of infringement. If the suit is not brought within this time, it's time barred, ratifying the infringement. Now, while patent litigation proceeds much like any other federal case, the complicated legal issues surrounding patent validity and infringement are reserved for the court's determination. although some patent litigations use juries for other aspects of the overall cases. Now, next slide, there's 3 key factors for litigation. Instituting an IP lawsuit, it's not a laughing matter. There's actually usually a lot of money at stake. Companies' reputation, businesses, are made or broken by IP lawsuits, and so therefore exceptional legal expertise is required, not only to succeed, but to begin handling such cases. And based on the above, these are 3 key areas that you must do before litigation, offense or defense, to make sure you have a strong infringement analysis. This is to determine the strength or likelihood of infringement of each and every claim of your IP, determine the strength of your patent, if there's weaknesses, and also assess your potential amount of damages. This is a significant investment of time, energy, resources, and I hope that none of you guys ever have to be drawn into this. But it's important to know. That this is just part of the commercial world that we live in, even the government world that we live in. There's a lot of lawsuits going on, and you can never be too prepared to have information. That about ends our presentation for today. This last slide, I do have a slide for additional resources outside of this particular slide deck. There's training modules on the USPTO website. There's a FAQ on data rights that the SBA gives you. The iEdison website, like I mentioned, is where you can disclose your invention if you're getting government funding and you want to patent something. These are just some helpful resources for you. But I believe we have a question and answer portion now. Right, Phil?
Absolutely. So, George, thanks for the overview. I wanted to take some time to address some of the IP questions we've been gathering during this workshop and prior to the presentation. But before we get to that, to remind participants, we will send a transcript of this webinar as well as slides and frequently asked IP related questions within 30 days. Also, I'd like to remind everyone that the information contained in this webinar and accompanying materials is for educational and informational purposes only. Nothing in the webinar or accompanying materials should be construed as legal advice or as an offer to perform legal services of any subject matter. All right, so with that, George, you've given us a lot of great information. I want to highlight a couple of quick questions we've gotten from the audience. The first one is, when should companies consider patenting an idea rather than maintaining it as an SBIR data right?
That's a great question, Phil. And I talked about this briefly in my slides, but let me just start this way. First, an idea without more is not patentable. An idea by itself needs to be refined, and how much depends on the particular technology. But once that idea is refined and can be explained or written down in a logical, workable invention in a documented form, that's when an idea becomes something that's patentable. And by definition, an invention that we're talking about, it's going to solve a problem. It's going to be able to do all those kinds of things. It doesn't have to be a great invention. It doesn't have to be a world-changing invention, and even one that necessarily makes money. It just needs to be more than just an idea. Now, if you have that, then you should patent as early as possible. Now, if you're getting funding from the government, then the question becomes a bit trickier, like we discussed. It becomes a business decision, a market forecasting type decision. If your invention has applicability only in government space, for example, and you have limited funds, and your technology is likely to be surpassed by another technology in 3 to 4 years, I would recommend you go with Sivir data protections. Now, if there's a greater applicability of your technology, there's greater commercial viability, and you have private funds to put into more research and patenting, well, then I would recommend going the patent route. It's really a balancing test based on a whole host of factors. But I recommend folks take a look at that chart that I provided. It's pretty general, but it's a good starting point, especially for those who are asking this question.
Thanks for that. You just touched on this, actually. So you talked about getting in early as possible. How does that apply to provisional patents? And so specifically, when should companies file for a provisional patent? Again,
that's another good question. I don't want to spend too much time talking about provisional patents, But I did mention in 2012, U.S. patent laws changed significantly. There was a large reform that went on then. These changes made U.S. laws more aligned with international IP laws. So long story short, U.S. is now a more first-to-file regime than it was before. There are a few exceptions with that. That's why I say it's more of a first-to-file. It's not a pure first-to-file. But these changes effectively render provisional patent applications less important than they ever have been. And just like I believe I mentioned this earlier, a provisional patent doesn't actually have any legal bearing. It's literally a placeholder. It's a timestamp for when you later convert to a non-provisional patent. So don't be fooled thinking, if you're filing or been recommended to file a bunch of provisionals thinking that you have legal rights. Yes, provisionals are cheaper, but you're just buying time. The provisional patents, if they're not well crafted, which they usually are not because they're cheaper, then you actually don't have those rights anyway when you actually convert. Now, there are two situations where I would recommend filing provisional patents. One, if they're well drafted and they cover most of the invention that you're trying to, develop. Now, if you think about it, if your provisional does all this, why not just convert it then to a non-provisional in the first place, right? The second situation where I would recommend a provisional is if you're presenting your invention to a customer or to the public, let's say tomorrow, file a provisional patent today. It's better in that situation. I think you'll get some protection than completely forfeiting it altogether when you publicly talk about your innovation to either that third party or to the public. Now, some large companies, they file provisionals very routinely. This is part of their built-in process. This is their way of just getting stuff on file, and then they prune these later on to figure out what's actually important to their business. Like I mentioned, provisionals buy you time, and so some companies build filing provisionals as part of their strategy. And that's okay, but this is costly, and you need to actually have a process or system in place to do this well. And so for most of the companies here, you probably don't have the resources to have this kind of implementation to be done well within your company's framework. So aside from these two situations, I would recommend that folks not consider filing provisionals as part of their filing strategy.
Got it. And that actually ties in well to my next question. You talked about sort of the compounding cost of all of this IP work. What are some tactics that companies can use to best manage patent costs?
Yeah, it's always a question about cost and money. Now, in terms of tactics, well, I don't know. I mean, it's just like for anything, right? It starts with desire and importance, right? Most people don't have patent funding because they actually don't view it as important. And it becomes important when it's too late. And I have kids, and I tell my kids if they want something, they need to plan for it, they need to save for it. And it's in some ways, it's no different here. If you want to protect your innovation, and all of you, I believe, have businesses that are built on innovation, you need to seriously think about how to protect that innovation, not wait until it's too late or blame somebody else. In this world, if you don't do that, someone else will be sure to steal it, design around it, or build upon your hard work. And so how do you manage costs surrounding, IT, surrounding your office furniture, surrounding this or that? I don't know. That's the same kind of tactic you would take managing your patent costs internally the same way. It's the same with value, but it does begin with valuing your IP. The other thing is to shop around, right? If you find a nice dress that you like, you might shop around before you buy it, right? Or you might say, hey, it's not going to be much cheaper somewhere else. I'm going to pay for it as is and save yourself some time. Shop around. It's a buyer's market in the patent world, and I don't mind saying that even as a private practicing attorney. You can get good prices out there. You just have to shop around. Unfortunately, there's no, Amazon marketplace for patent services, so it might take a little bit more time to figure out what the going rates are. And if they are too expensive, they probably are. If they seem too good to be true, they probably also are too good to be true. You built your business on good judgment, and so don't stop there when it comes to managing your patent costs.
Thanks. And we just had a really good question come in. So it looks like we can agree that an invention cannot be patent protected after it's been publicly disclosed. And the question is, does the SBIR application process constitute public disclosure?
No.
Got it. Okay. Okay. Let's say I've been awarded a patent for my company. What does that actually mean for my product, and what does it actually protect?
So you've been awarded a patent, and what it's actually protect, you own a very expensive piece of paper. I guess a patent ultimately gives you a lot, actually. It gives you peace of mind, it gives you leverage, it gives you licensing potential. It's all built around what we discussed, which is the ability to exclude others from making, using, or selling your patented invention. So if you have the ability to do that, it actually goes a long way. So I was kidding about the piece of paper, but you will get if you do get a patent, you will actually get a piece of paper, your patent, and it'll have a nice, pretty ribbon on it. But in addition to that, you get the ability to exclude others from practicing for that particular duration, and that's worth a lot, especially when it comes to licensing potential, when it comes to negotiating and leveraging. You can get a lot out of that. And peace of mind to know that if someone does copy you, you have legal recourse that you can take. That goes a long way.
Got it. And you actually just touched on my next question. So regarding recourse, what recourse do companies have if a dispute arises during the course of the SBIR project regarding IP rights between the small business and one of their subcontractors?
Yeah, so just, is your question, is there recourses? Yes, there are, several resources to pursue legal action. I guess it's valuable to know if it's worth the investment. It depends on the invention, depends on the market. I think ultimately it's a business decision that you have to make. Now, as a patent holder, you have lots of options when you get a patent, and most of it's not just it's not as resource intensive as you think. So if you want someone to stop making or using or selling your patented invention, you can send the cease and desist letter. Right? If you want a license, you can go ahead and approach someone and bring your patent with you and say, hey, I want to license this technology to you. If you want to sue, you can sue. And most of this, it actually won't cost you anything or cost you very little. There are tons of attorneys out there, lawyers that build their practices in this space on contingency, meaning they only take a cut of what you can recoup at the end. So there's no upfront cost, especially if you have strong claims. Now, these particular lawyers, they'll take you on as a client if they believe that there's strength in your IP, and they believe in your business, and they believe that there's value in defending or getting into this market. So, there was a situation where I worked with this old man. He had literally too many patents, and he didn't know what to do. It's like that lady who lived in a shoe, and he literally had no idea. He came to my firm. He sat down. We talked about all his different IP. We basically built an IP strategy to go after, all these gaming companies, digital cameras, et cetera, because he was just a prolific inventor who just didn't have any understanding of what to do with these patents. And so we sat down, talked about that, and we were able to recoup him millions of dollars at the end for his retirement. Another example, when I was with GE, GE actually develops a lot of IP not only for its core business, but non-core as well. Or maybe businesses change, right? And so you're getting IP for something you think will be part of your business, but then your business goes in a different direction. So they wind up having all this IP in non-core space. I helped them build a licensing program for that. Basically, IP that was basically you're spending money to maintain these things, or they're going to expire in a couple of years. Otherwise, it's just dead weight. We took that non-core IP and developed a licensing program and recouped about $5 million for GE for stuff that would have just gone without anyone noticing, and got some money out of that. So there's a lot of recourse that one can take, rather than just pure legal action. And with that, with that question, there's something I forgot to mention. Maybe this is a good time to mention it here, Phil, because I remember working with you guys and talking with a lot of folks. People talk about shared IP rights, and I did want to put my 2 cents in here. Is that most of the time when people are jointly developing or jointly owning IP, from my perspective as a good IP attorney, you want to try to avoid any type of jointly owned IP, and you want to do this, upfront as possible. Decide who's going to own it, who's going to pay for it, who's going to maintain it, who's going to have rights to it. Part of the reason I bring this up is because I see too many situations, especially with multi-parties, joint development, people, different companies working on different things. People just think it's a nice way to have shared or joint ownership of IP. Now, I want to give two examples to help us understand why this is not a good idea. The first example is real estate. We can have a debate about whether it's better to buy or to rent real estate, right? And the answer is it all depends. It's better to buy real estate if it's going to appreciate, if maintenance is not too strenuous, and it's all about the investment potential if you're buying. Now, renting is better in some cases if you want to have all the privileges without the maintenance, and maybe, but then you don't get that investment potential at the end. So whether you rent or buy, all of that's spelled out in lease agreements or contracts, and these issues of joint ownership are predicated on these agreements and contracts in place. Now, the second example for shared IP comes into, that it comes to mind is like child custody. I know that's something that most people don't want to think about, but joint ownership of IP rights, most people think that, well, if I work on this with somebody else, they have 50%, I have 50%, but that's completely wrong. Both of you have 100%. I'm married, I have kids. My wife and I are expected to make decisions jointly for our kids, but the reality is that as a parent, I can make 100% of the decisions for my kids at that time. It might not make my wife happy, but it's my legal right at that time, just as it is hers. But you can imagine in an IP situation, this can get pretty hairy. If this happens with children and marriages all the time, just imagine jointly owned IP. This is why you want to be able to hammer out who owns what as upfront as possible. And it's not necessarily always important that you own IP. If you own it, you have to take care of it, you have to maintain it, etc. It's okay to actually sometimes just have unlimited visitation rights, so to speak. Sometimes that's better than owning it. And so I did want to just bring this out because this is an issue that I see a lot, Phil. And trust me, jointly owned IP almost ends up with some sort of lengthier, more hostile, more costly dispute at the end. So to the extent possible, companies should try to avoid jointly owned IP and try to figure out who's going to own it, who's going to take care of it, all those things up front in any contract.
Got it. I want to take it back a few steps for this next question. I think it's a really good one.
Okay.
You've worked with a lot of small businesses, so I wonder your thoughts on this. What steps do small businesses take during the life of an SBIR to identify IP developed? Like, I guess the question is more, how do you know when you're sort of in the realm of where we need to start having it, when we're breaking new ground enough for there to be IP?
Yeah, I think it's important to maybe develop a small internal team within a company. It doesn't have to be new people. I would probably tab a chief scientist or chief engineer or chief developer, to think about and identify IP. I know when I was at BikeCube with you guys, I sat down with one of the companies and came up with a list of things that they were working on. And we talked each one through. We talked about the competitors. We talked about the future business of things. We talked about value and money, time frame for development. And at the end of the session, we made a list of what could be patented, what should be kept as trade secret, timeline to do all this, budget, cost, alternatives. I think this is worth doing if you can, find someone in the company, like I mentioned, like a developer, engineer, someone who knows the business and knows the technology a little bit, and maybe just write that into their business, into their role.
Sure. And I guess along those lines and sort of thinking about business structure and who's on the team, who's not, do companies need an attorney to help them with IP protection? Or is there I know some people may try to find a workaround. Just would love to get your thoughts on that.
Well, as a practicing lawyer, I'd like to say yes. But the reality is, you don't need a lawyer. If you want to do it right and hopefully not do it again, it's probably a good idea to get legal expertise. But if you don't have the resources or the finances to do that, there are other ways to do that. Like I mentioned, maybe find someone who knows the business well, someone who knows the technology well, and just write that into their sort of employment. And I think it should be it should go a long way. Now, like I mentioned, with litigation, licensing, negotiations, some of these things get a little bit more complicated. Maybe prosecuting a patent, for example. So you might want to seek legal expertise for that. I would recommend that for those situations. But if you're just trying to figure out what inventions you have, what to file, you can have someone internally write that into their job description.
Got it. So turning back to sort of the SBIR world and getting a little more granular with that, how broad is the definition of government purpose rights? I mean, does it apply to the program level, the project level, or is it broader than that?
Yeah, the government purpose rights is a pretty broad language. It's usually for national security reasons. I haven't seen situations where the government proactively does that, but it depends on the regime. We're in a different political presidential regime now, so I don't know. I can't speak to what the government will do, but in terms of history, the government hasn't actually elected to go on government purpose rights or elect their marching rights unless they really had to for national security reasons. So for the most part, that's a pretty safe bet, but again, in different regimes, things are safer than others. So I can't predict, like many others in this particular regime.
Sure. Similar track of questioning. If a TPOC asks a company to report an invention on a DD 882 when they're not interested in pursuing a patent, if they don't elect to file, does the government get the right to own the IP?
Can you repeat that again?
Yeah. Let's say a TPOC asks a company to report an invention on the DD 882 form, and the company chooses not, and they're not interested in pursuing a patent on that invention. So if they don't file the form, don't do the DD 882, what position is the government now in? Can the government, exercise its own rights to the IP?
Correct, they can. Now, the government could exercise their own right even if they didn't request the company to file a patent on it either. So if the company had something and they just simply didn't report it based on those 3 steps that I mentioned, then the government would have right at any time to procure a patent on that technology.
Got it. And this kind of goes back to our
the company.
Go ahead.
Oh yeah, sorry. If the company did actually take the first step to just disclose it, the company might be somewhat protected by having licensee rights should the government then proceed themselves. So the company could still use it, supposedly, but if there's no interest in it, those are the things that get forfeited if the company doesn't take active steps moving forward.
Got it. I think this is along the same line, sort of. In the SBIR policy directive, they talk about government use rights and the idea the government gets a quote unquote royalty-free license. And so would love to hear your thoughts on, can you give any examples on what the government can and can't do under the quote unquote royalty-free license?
Well, there's not much again, every license has its own contract, so you'd have to look at the specific provisions. But if we're just talking generally, a royalty-free license per usage of the government under general FAR, DFAR rules, the government can probably do almost anything. Now, as the owner, you can also do anything. So you become sort of if we're chasing after a third party for business, for example, you can be a competitor. So that's the downside of government having rights to your IP, is that these rights, though they might not be ownership rights, they give you a lot of leverage. They could shop that out too, since they're not exclusive. Got it.
And I think you may have touched upon this during your comments, but does the government's royalty-free license use, when does that kick in? Is that after the SBIR data rights protection period or another point in time?
Yeah, I think one thing that we have to kind of be clear of is that the first part that you mentioned in terms of the royalty-free license, that usually applies to patents. Now, when we're talking about data SBIR protection, that's a different type of IP. So we want to just make sure we separate out the IP, the different types of IP, because these different rules apply to these different things. So if we're talking about patents and we're talking about the government having a royalty-free license on a particular patent, that's one thing. If we're talking about the data rights, it might not actually even overlap, or if it's a totally different set of, data that we're talking about here. So it doesn't necessarily have to conflict with each other.
Got it. And George, I know you've worked with a lot of firms. I kind of more corporate-wide, particularly in the SBIR world. Can you, I guess, remind everyone, are IP expenses allowable or unallowable in terms of billable costs under the SBIR, under an SBIR contract?
I guess it depends on the contract. I believe, I know that there are some government entities that actually have that built in. If I'm not mistaken, I believe NIH or NIST, as part of their funding, has a portion set aside for IP.
Got it.
Now, these are largely research-oriented government entities. Now, DOD is so large, and so many distinct entities.
Sure.
You probably have to inquire about each entity: Navy, Army, Air Force. I think the challenge is with these is that even if they do, sometimes by giving you money, they'll want to have some sort of ownership rights to it as well, or some sort of rights. So you have to decide, what it is you want before you go down that route anyway. So I would say it's possible, but you have to look at each specific government entity.
Perfect. And then final question. Is there, and we might have touched on this before, is there a tool sort of best practice for tracking IP generated before a contract starts, or do you again recommend sort of having someone on staff who just constantly is sort of the quote unquote IP person, I'll call it?
Yeah, I would recommend having someone tabbed as sort of the IP person in the company. I think it's important to have someone that has a understanding of how to figure all that stuff out. You need a point person there. So I would definitely think about that or recommend that, like I mentioned earlier.
Perfect. Well, George, I can't thank you enough for taking the time to give us your thoughts today and to answer some of these questions that we've gotten throughout the discussion. I wanted to see if you had any closing comments on your end before we moved on to the next section of the webinar.
No, I think I just want to thank you guys for having me. I think it's always wonderful for me to have opportunities to share with people about IP, because there's always so much question and so much confusion and so much apprehension towards IP. I think at the end of the day, my job is, again, just to help people to understand some of the issues. If after this presentation folks have red flags popping up left and right, or they're thinking about things a little bit more IP-oriented, I will know that I've done my job and really help people to at least be aware of the issues. It's better to have red flags popping up and down than to not, and then only later on to find out that your IP has been compromised, your business has been compromised. And so it's a good thing in my book if you're thinking about these issues more, and folks are looking at IP a little bit more seriously and trying to build it into their business plans, into their marketing strategies. And to me, that goes a long way. So again, I appreciate the time, and I appreciate everyone being able to join today.
Absolutely. Thank you. So I'd now like to introduce Jason Talley, the BiteCube Training and Advocacy Project Manager, to take us through the upcoming.
Hey everybody, thank you for joining today. And once again, I want to thank George and Phil for getting us through today's workshop. Hopefully there's a lot of valuable information shared. So our next 4 upcoming workshops is, the first one is understanding the evaluation process and what to do with a debrief. And we're going to cover the BA process, the eval process, and debriefing and how to use them, and also the commercialization planning, and also the importance of a commercialization plan, and also proposal compliance. That's on June 26th. On July 17th, we'll be working with prime contractors, and we'll have some prime contractors on our panel talking about how to do work with them and best prepare yourself to do work with them. On August 1st, we're doing the DOD acquisition process and contracting, and really walking you through the whole DOD acquisition process and really preparing you for how to look for money, how to look for different proposals, and how to prepare your company for that. And also on September 4th, we'll do commercialization assistance programs and beyond phase 2 considerations. So really helping you figure out how to take your company beyond phase 2 and get yourself ready to do work with prime contractors. And this coincides with our Save the Date, which is for our 2018 SBIR STTR Beyond Phase 2 and Mentor Protege Training Week, which is August 14th through the 16th in Orlando, Florida. And the attendees for this is going to be small businesses, large businesses, federal government, SBIR program managers and key staff, DOD Rapid Innovation Fund staff, also known as RIF, DOD Mentor Protege program managers, and also DOD Mentor Protege companies. So this is a great opportunity for this full week to learn how to better prepare yourself for beyond phase 2. This includes information sessions with speakers that provide small businesses with insight to develop innovative solutions and progress their SBIR technologies beyond phase 2. Attendees will also learn how to leverage the synergies between the SBIR program and also to the MPP programs. Breakout sessions will address topics such as government contracting, strategies for growing your small business using the SBIR program, and SBIR commercialization programs. There's also scheduled one-on-one sessions that will afford small businesses the opportunity to meet with key personnel from the government and also from industry who support DOD SBIR, RIF, and MPP programs. The event registration fee is $470. A registration website will be available very soon. So I do ask that you take a few minutes to visit us at bit.ly/beyond phase 2. And you can subscribe to this website to find out more information on this upcoming conference. So once again, and we've gone through this, and also actually go back one more time, sorry. Here's some more things we kind of want to show you about the program. Joint plenary sessions, once again, this is going to help you get caught up on latest policies, procedures, and practices within the Defense Acquisition Community Program. Also, a key thing there is also our non-peri awards. And to take part in this, basically, if you're part of the Mentor Protege program, you'll be recognized, or companies will be recognized for the exceptional accomplishments between the program and also proteges. Okay, next slide. So we ask that you do please leave comments about this session. We would like your feedback, and it helps us inform how we do our next ones. Any questions or comments, please connect with us at sibirtraining@bitecube.com. And also take some time to create or revisit your IP strategy. And once again, thank you for your time.